Hello, everybody, and welcome back to SEC Roundup. I'm Nick Morgan, one of the co-founders of ICANN, Investor Choice Advocates Network, and a co-host of today's episode of SEC Roundup. Joining me, as always, as co-host and co-founder is my friend, Tom Zaccaro. Tom, how are you?
I'm doing well, Nick. How are you doing?
Very well. Very well in particular because of our special guest today. We're joined by David Slovick. David is a partner at Kopecky Schumacher Rosenburg, previously served as a senior attorney in the enforcement divisions of the SEC and the CFTC. We're also joined by Professor Phil Lieberman, who is a professor at Vanderbilt Law School. He served 3 terms in the SEC Scholars Program, including 1 in the Division of Enforcement. David, Phil, thank you for joining.
Thanks for having us.
Thanks so much for this opportunity.
The occasion is prompted by a series of articles you both wrote relating to SEC civil penalties and the sort of arbitrariness of those civil penalties. So, Tom, before I turn to Phil and David to talk about some of the data they found and some of the recommendations they make in their articles, why is it important, this issue of the arbitrariness or consistency in when the SEC assesses a civil penalty against a defendant or respondent in an enforcement action?
Well, we all like to believe that the government treats us fairly and that their assessment of penalties is a considered judgment of the agency. And I think we've seen over the last 2 decades that that is not the case with the SEC. It does it from a practitioner's perspective. It's sometimes hard to understand what went into the SEC's calculation of penalties. And, the most recent financial reporting from the commission is that in fiscal 24, they assessed over $2 billion in penalties. And from a, defense lawyer's perspective, it's a due process issue. There ought to be fair notice of how penalties are calculated by the commission to give the defense a chance to meet those penalties or rebut them or challenge them. Yeah. But I think, and I first started seeing this back in the market timing cases in the mid 2000s when the commission started assessing $50, $100 million penalties without any relationship to disgorgement or the actual violation. So luckily Phil and David have drilled deep into this. There was some perspective about whether my whining is accurate or not accurate.
Well, we'll find out in a minute, but I'm sure Tom and David, you've probably had this experience where you have a client, potential client, former client come to you and say, I just read an SEC litigation release about a new matter. They settled the matter. The person involved did far worse things than I did. Let's say it's like an investment advisor and comparable, some, violations similar, and their penalty was much lower than my penalty. And Tom, how do you explain that? It's really hard to explain if there's very inconsistent assessments of penalties for similar sets of facts. That does make the system seem hard to explain. So an important step that Phil and David took toward explaining what's out there is just the collection and explanation of the data. It's one thing for all of us to sit around and point to this case or that case anecdotally, but to methodically collect the data on SEC penalties, I think, is an important service for everyone, including people at the SEC. So Phil, I understand you had the laboring oar on the data collection and analysis. What did you do and sort of what did you find?
David and I this past summer had a conversation very similar to what we're going through now, and came to the conclusion that, a lot of the time there is a sense among clients that, a previous penalty, is just less than theirs. And there was a sense that penalties were just kind of getting walked up. I'm, someone who appreciates the use of data in my own research. And as we say in the article, I wanted to create a database of the SEC's actions. So I used Python to draw down from the SEC's own website their litigation releases and then created a database going back about 20 years with all of those litigation releases, and then used AI to help me write the Python code and pull out, who are the various parties involved, what was the penalty amount, what was the disgorgement amount, what was the relevant statute that was cited, and so on and so forth, which allowed us to create this whole big database. And then I could start playing with the data. Now, I'm not the first one to think about this. Since 2009, there's been a database at NYU called the SEED database, Securities Enforcement Empirical Database, where, every time the SEC, has its closed commission meetings and so on, and then the law students at NYU Law actually review the data from those releases. So their database, to be honest, probably cleaner than mine, but mine is larger, right? It's the first time that we go back to all of the releases that the SEC has produced that are available on its website. So the data set comes right out of the SEC's own litigation releases.
That's fantastic. And I'm super intrigued by the use of AI, hopefully not replacing the law students and their good efforts, but as a supplement to the data analysis. So you collected a vast amount of data. Can you highlight for us some of the trends or things that you observed in that data?
The first thing that we see is that, you can't just look at the penalties in terms of their dollar amount, right? So, I had to not only draw down the penalties themselves, but those penalties are, naturally going to walk up over time at some rate, whether it's inflation and so on. So I had to sort of do a join of the SEC's penalty tiers. Again, this is all like public information. And then, look at how the penalties were walking up vis-a-vis the penalty tiers. But here too, if you just sort of look at kind of a straight up ratio of the penalties to the penalty tiers, that's not going to tell you much, because sometimes there are really, really large penalties that get assessed. So if you look in the articles, we're not just, looking at this ratio of the penalty to the penalty tier amount, but we actually use a log scale, right? Which says if something is, 10 times more, then that's a, 2.0 log scale, or 100 times more, that's 3, right? And so, we have to slice and dice the data, but then start trying to, produce something that makes sense from the data. And so we use the log scale to sort of show how over time, right, kind of, perhaps not surprisingly for natural persons, we don't see this kind of walking up, but where non-natural persons are involved, yeah, there is this kind of walking up, a trend line that goes, higher than, where the penalties are, sort of laid out by the penalty tiers, but they continue to go up at a faster rate.
Interesting. And one of the words you used in the title of the article, and maybe it wasn't your title, maybe the editors picked it, but was how the framework became arbitrary. Did you see in the data signs of arbitrariness?
I mean, I think that the fact that the penalties are moving beyond what the tiers allow suggests that it's not just the tiers themselves that are dictating this, right? But there must be something else in play, of course, because the data is just the data. We're not and because the litigation releases don't give color as to what it is that allows us to sort of see into the black box of how those penalties are set. It's really difficult, and this is one of the things I think that that David was really clear about in his contributions to the article, that we need greater transparency.
Right, right. Well, that's maybe the perfect transition to you, David. I think another great service that your series of articles did, in addition to the data collection and analysis, is that the final piece makes some recommendations. But before we get to your recommendations, maybe just give a high-level description of the 3 tiers, so that the audience who's not maybe familiar with it can understand that there is a statutory framework that is supposed to guide the assessment of penalties in SEC matters. So maybe for those who aren't lawyers or who aren't familiar with it, what is that scheme?
Sure. And you're absolutely right that it's easy to forget that those things exist because they get lost in the shuffle when you're trying to resolve an SEC case, or when you're talking about resolving it with a judge. But there are, as you say, distinct tiers in all of the big securities laws. They're analogous in the 34 Act, the 33 Act, and the Advisors Act. And basically what they do is they try to break down and categorize violations by their severity. And then as the severity of a violation increases, to assign to it a higher penalty amount. So the lowest tier is the first tier, and that is the tier that allows the commission to assess a penalty for any violation of securities laws. The next stepped up penalty is a second tier penalty. It is for penalties that involved basically intentional or reckless misconduct. So not just a mistake, but some severe or more severe misconduct. And then finally, the third tier of civil penalties, which is the one that carries with it the highest amount of penalties in dollar terms, is reserved for that conduct that led to investor harm or could have led to investor harm. So it's not a bad statutory plan, right? The idea is the worse your misconduct, Mr. or Miss Defendant, the more money you're going to have to pay to the SEC. So as you say, it is baked in there, right, to all the relevant securities laws. And as Phil mentioned at the top, the government has since walked it up even more to keep up with inflation. So the idea is the amount of penalty that you are going to have to pay is calibrated not only to what's going on with the economy at the time you get hit with the penalty, but also calibrated to how bad your conduct was.
One of the ways in which, I mean, I agree with you. I think the three tiers, that makes perfect sense. Just some logic, higher penalty for worse conduct, but one of the ways you point out in the article that this statutory penalty scheme kind of goes off the rails in application is the ability to assess a penalty for each violation. Can you talk a little bit about that?
Sure. And this is something that I have firsthand experience with. I'm sure you do too. I don't want to call it gamesmanship, but
go ahead.
Let's be curious and say at the most it's a little bit sloppy or lazy. The three tiers that you just talked about, Nick, they're calibrated in terms of a violation. So for each violation, the statutes originally carried with them a specific dollar amount. So if you make one false statement in a document that you give to investors, you're a public company CEO, well, that's one violation. You do your math and you say, okay, one violation should result in a penalty within this certain tier. If I make two misstatements, logic dictates that then you have twice as much of a penalty amount. And that's all pretty rational. What constitutes a violation is not laid out clearly at all in the statutes. And one of the ways that staff attorneys, if we want to be critical, say game the system, is they will say, all right, well, it's not just that you made one misstatement in your, 10K. I can identify 30 misstatements in yours. So it's 30 times top tier penalty. Or another way that they do it that I didn't mention in the article is they can say, look, this conduct took place over 70 months, and so we're going to hit you with a top tier penalty for each misstatement for each month. And you can see how that can result in just a gigantic penalty.
Yeah.
So that's how the violations, I think, originally became the cart that led the horse instead of vice versa.
Yeah. Yeah. So the last piece of the article, which I think is very helpful, you make some recommendations for ways that we could try to get this back to what I think all reasonable people could agree. You want more serious penalties for more serious misconduct. You want less serious penalties for less serious conduct, and you want some consistency. What were the recommendations you made, and why do you think they would help?
Well, these are ways that I just thought of, based on my experience on both sides of the table, that we could take control away from the line level staff members who often have very little real world experience, don't have a good idea of how civil penalties affect, the entities in particular and the individuals that get imposed on. And for staff attorneys, and I do hate to say it, but I see it all the time, throwing around $100,000 swings in penalty amounts for them is just in a day's work. They have no concept of how that can affect a business or in particular an individual. But my ideas basically come down to the commissioners themselves wrestling away control of these decisions from the staff or imposing greater oversight. So one of the ways that the commission could do this by rule is to just to take away the discretion by defining what a violation is. So no more gamesmanship with violations. A violation means X, and it can only mean X, and so it's a mathematical formula. Another way that I thought that we might be able to get around the staff's abuse of the violation game is to make the staff disclose very clearly when they're seeking authority from the commission on the front end to explain exactly what the violations are, exactly what their math looks like, and ask the commission for express authority to do it. And then if over the course of the investigation, as you know, that number changes, sometimes it does, the commission should be obligated to go back to the commission to change it, either up or down. And then the third best, what I call the third best solution, because I think it would be helpful, but certainly isn't going to dictate any outcomes at the commission, is publish, publicly what you're doing in settlement orders or in a section of an ALJ's decision or in a final commission opinion on a litigated matter before the commission. Also, we talk about the fact that in a district court setting, district courts have, the judges have all the authority so they can do whatever they want with penalties. But it would be helpful if the staff were obligated to show that same math in a proposed order to a district court, because district courts usually defer to the staff on how to think about penalties. So
Right.
I think the touchstone for all is just disclosure, more information to the decision makers who ultimately impose the penalties.
Yeah, I think those are very helpful. Go ahead, Phil.
Yeah, just add to this that, if you look at the data itself, right, you see something that, everyone who sat in on a closed commission meeting knows, which is at the end of the fiscal year, the dots in our charts get more dense, right? There is more of a push to settle, and so on and so forth. And so, as long as we score ourselves, right, as long as enforcement scores itself based on, the number of matters that it settles or the amount of the penalties and so on, we're going to see, more and more matters, push through at certain times and the penalties walk up. So, we have a kind of a structural incentive problem here that is perhaps contributing to this.
Yeah, no, that's an excellent point.
Well,
Yeah,
I think it seems like he's ready to take on some of the excess in the enforcement division.
yeah,
So
yeah.
we'll see what he does.
I was going to say maybe Phil and David's article gives a framework.
I think this was part of our hope that perhaps, Chair Atkins, the other commissioners might even see our article because, it is quite clear to me that, they're concerned about, protecting the investor and, and facilitating, capital formation. And it's not clear that the current penalty system is achieving their goals.
Yeah. And Nick, you mentioned before we got started that anybody who's in this universe knows, and certainly any defendant in an SEC litigation knows that this is arbitrary. It seems like the article is stating the obvious, and I agree with that. The data that Phil was able to dig up certainly put a frame around it that makes it more compelling, right? But really, one of the things that got us thinking about this is Chairman Atkins. I mean, he came in and gave a speech that we talk about in the article in the fall, I think it was in October, where he said very clearly, look, I want to change the way that we do the Wells process and get back to a fair and open Wells process, which, as you two probably know, also has completely changed and closed down over the past 20 years.
Yeah.
You can't get a scrap of information out of the commission anymore until you get your complaint on ECF. So one of the incentives certainly was that we are hoping that Chairman Commission will give this, a look, because it has truly gone off the rails and it is arbitrary. Arbitrary is a word that we picked and gave to Law 360, and they thankfully didn't change it because I think everybody agrees that's what's going on here.
Yep. Well, fantastic. From your ears to the commission, your lips to the commission's ears. Gotta get that in the right order. David, Phil, thank you so much for joining and for sharing your thoughts and analysis with us. Tom, as always, thank you for co-hosting. For everybody else, if you want more information on ICANN, go to icanlaw.org, and we will see you on the next SEC Roundup. Thanks all.
Thanks, everyone.
Take care now.
Take care.